Hello friends, I am Arun Tiwari, and in today's video I am going to tell you 5 important legal documents or legal terms which you must be aware if you are planning to buy property in India or planning to sell property in India. In both cases, these 5 terms are very important and you should be well aware about that. So let's begin. So hello friend, my name is Arun Tiwari and generally I make videos on NRI taxation, NRI property sale, and today I am here to tell you 5 important terms or legal documents you must be aware about them, what is their uses, what is their importance before you buy or sell any property in India. So very first document or legal term you should be aware is called MOU, Memorandum of Understanding. Memorandum of Understanding is basically the very first document you are going to sign when you're planning to buy or sell a property. So what is this? So Memorandum of Understanding is basically signed once somebody like your property or somebody want to buy your property and they want to see your papers. Now before giving them your papers or the copy of the papers, property papers, you want some kind of surety that those people are serious buyers and you're not wasting your time with them. So what you will simply say, you will ask some token money, and in return of that token money you will give them your property papers, and you sign a simple paper which is generally printed on 100 rupees stamp paper, and there you mention, you both agree on some initial terms. Now understand, these terms are not enforceable by law, but these terms are going to be used when the final property documents are drafted, like agreement to sell or sale deed. So those time this document will become a base. It's always advisable to sign or to draft and sign a MOU, because later on it will reduce a lot of you can say complications, unclarity, because what happened, property buying is a, you can say, big exercise. It at least take 2 to 3 months to get into, and in between so many things we discuss, we talk, and maybe things are getting overlapping on each other. Sometimes we see the prices itself get revised here and there because it happens. So if there is something in writing, always buyer and seller both can rely on that and they can reduce unnecessary disputes. So always get signed it. Now in MOU there are some standard terms or standard things we agree, and one of them is the price on which the property is agreed to be bought or sold. Second thing is days which seller provide to buyer to pay the balance money or get the loan approved and distributed to or to pay to the seller. So these things are basically agreed in advance in MOU. So always sign an MOU before. As a seller you give copies of your property documents, and as a buyer also it's always better to sign. There is another benefit to buyer also. The buyer generally in MOU, seller gives him a timeline, maybe 15 to 30 days. Within that the buyer has to go to their bank or to lawyer and get a whatever search report they want to be, so that they are sure, buyer are sure that this property doesn't have any issues. Between that 15-20 days or 30 days, whatever period is given in the MOU, the seller is obliged not to engage with any other buyer. So at least buyer is also sure that he is running around, so at least the property will not go to some other competitor. At the same time, seller is also sure because he got some token money and he knows that this person is serious, he is seriously looking at his property to buy. Now there is another problem, generally people ask, so the token money should be refundable or non-refundable. See, this is a mutually agreed term. In some cases buyer or seller can agree that if the buyer doesn't come back, he will forfeit all the token money. But in most of cases, especially where the time is not essence or the seller definitely do not want to create a legal issue, because understand, if somebody is giving you 1 lakh or 5 lakh rupees token money, you can just forfeit it. Of course he is going to take some legal action. You definitely do not want to create a hurdle by keeping that token money. But again, this is a mutually agreeable terms. If buyer seller are agreed, they can decide whether to forfeit or not to forfeit. This is completely upon us. There is no particular law about the token money should be forfeited or should not be forfeited. There is no such particular prescription is there in the law. So this is also done. So first thing clear, MOU. So very first document or term you will come or you will hear when you go for buying or selling properties called MOU. Second term you are going to hear, which is again a legal document, is search report. So what is search report? So search report is basically, see, once the buyer will give you token money, you will give your property documents to him, he will take it to his lawyer, and the lawyer will check all the legal records about the property, whether the property has any issue, legal dispute, any charges on them, okay, free from any encumbrance, there is any loan. So all the background check, all the history of the owners through which the property has passed will be checked by lawyer, and the lawyer is going to submit a report to buyer. Generally buyer engage them because buyer is interested in the buying property, and only after that legal report, which is called search report, buyer will decide whether to go or not. Suppose there is some legal issues or some disputes, definitely either buyer will not like to go, or definitely he want to clarify from seller or want some kind of indemnity. So this is very important, that if you are buying a resale property, especially a property from other buyer, not from directly from builder, because most of cases the builder's property are new, all the approval and everything is new. So I'm not saying it's not required, but most of cases if there is a reputed builder, it may not be required, okay. But if you're buying a property in resale, you should do it. Now there is another you can say smart way of doing this. You take a loan. So whenever you go for a loan, generally this search report is done by bank on your behalf before they give you a go ahead whether they can fund this property or not. So it's always a smart idea, and always I say that even you have full money for the property, at least take some loan on that property, because once you go for a loan, this due diligence, this search report is done by buyer from their panel of lawyers, and they do it much better way than you can do it, because see, first thing, they have lawyers who are expert in that. Second thing, in no property where bank feel it's a gray area, they will go ahead and fund. So it's a very good indication once bank give you a guarantee or give you a kind of sanction letter. So insist a sanction letter from bank, and if bank gives you a sanction letter, that means in principle they have done everything, they have checked it, and they are ready to fund that property. So in 99% cases, if the property is weighted by bank for the loan, this will be free from any legal and encumbrance. 1% there can be still a chances where bank can also be fooled for that. So always either do yourself or take a loan, but do a proper search report whenever you are trying to buy a property from resale from another buyer. So this is the second legal term or legal document you will hear, and you should be taking care of this. Third legal term you will hear just before registration. So what happened after you get the you can say search report and your lawyer is okay or your bank is okay about the property. Now next thing comes that you have to pay your own contribution, whatever contribution you have to make as a buyer to seller, and then you both buyer and seller will go for a agreement. This is called agreement to sell. This is a legally enforceable document because you are going to pay stamp duty on that. So any document which is drafted, signed and registered will become legally enforceable. That means that can be proven in the court, that will be acceptable as a solid evidence in any court. So understand, the next document definitely I will talk about agreement to sell, but before that one more document or one more term come into picture, which is called valuation report. Now why valuation report is important for buyer and seller both? So let me tell you. So generally what happened, the properties which are quite old, maybe 30 years, 40 years old, right? So what happened, you have to pay stamp duty on their market value or agreement value. So before you go for agreement, the registrar want to know what is the market value or actual value of that property, because if the market value is less and your agreement value is more, always be sure if the property is slightly old, maybe 10, 20, 30 years old, specifically before the property exists before 2000, the year 2000 I'm talking. So you should take a valuation report. Now valuation report has to be submitted to registrar also, because the registrar want to know what is the value, market value of the property, and if the market value is more, your agreement value is less, they will ask you to pay stamp duty on market value. Vice versa, if the market value is less but agreement value is more, which is going to be mostly the case, then you have to pay stamp duty on your actual. So I will give you just an example to understand. Suppose market value of a property is say 60 lakhs and you are doing an agreement of 50 lakhs. So you have to pay stamp duty on 60 lakhs. Reverse wise, if suppose market value of a property 50 lakhs, but you are actually doing an agreement of 60 lakhs, so you have to pay stamp duty on 60 lakhs. So that's why it's very important to get a valuation report, because what happened in mostly old assets or maybe open plot or something which is more than 20-30 years old, always the valuation report gives you better idea than anything else, right? Further, the seller will require this valuation report at the time filing of IT return also, or at the time of filing of lower TDS certificate, which we call LTDS. So even buyer will require for payment of stamp duty, and seller will also require this report, which is called valuation report, at the time of filing their IT return or filing lower TDS certificate applications. Now the question is, who gives this valuation report? So valuation report generally given by their architects, which are registered as a valuer, and generally they are on panel of income tax. So always get your valuation report done from somebody who is registered as on the panel of income tax, and generally the valuation report given by them is acceptable by registrar as well as the income tax. So, and this valuation report has to be taken by seller. It's a duty of seller to take the valuation reports, because he has to justify that he is giving proper stamp duty by buyer, or at the time of filing return also seller has to produce this document to his CA so that he can file a proper income tax return. Document number 4, as I told you, agreement to sell. Now agreement to sell, as I told you, once the buyer will pay his part of contribution. Okay, for example, the property is 1 crore and buyer want to pay say 30%. So 30 lakhs he will pay to the seller. Now this 30 lakh he will deduct two things. First, the token money. Suppose he given you 5 lakh rupees as a token money, so he will only pay you 25 lakh rupees. And then he will also deduct the TDS part. Like suppose there is, if you are NRI, then the TDS is if the seller is NRI, then TDS rate is approximately 23%, right? So generally he will deduct from this part, or you can request him to deduct from the final payment part. This is up to you, but the TDS part will also be deducted. It will not be paid to seller, it will be paid to the government as a TDS filing. So what happens, once buyer will give his part of contribution, then seller and buyer can fix a date and they can go for registration of the document, which is called agreement to sell. So agreement to sell, as I told you, is a legally enforceable. Once this is registered, nobody can back off. Like backing off from there is possible, but it is painful. It's a long process and it's painful. So once the agreement is done, that means the buyer doesn't get the property, but he gets the right to buy the property, provided he fulfill all the conditions mentioned in the agreement to sell. Now what is the main condition? The main condition is that buyer is obliged to pay the balance amount to seller in the number of days provided in the agreement to sell, and this number of days is generally 45 days to 60 days from the date of agreement, which is provided to buyer to either make payment of balance himself or arrange a loan disbursement to the seller, right? So this is also you should understand. Now some places what happen, that people pay 100% from their own pocket, they don't go for loan, they have money, right? In that case, the agreement of sale is not done. Directly they can go to sale deed. So sale deed is basically done deal, when the buyer will pay you the full amount and seller will hand over the possession. Okay, so in some states what happens, people don't go for agreement to sell, they directly go for sale deed when they don't have to involve a bank for the loan. As I told you, always it's better to involve a bank, not because you want a loan, because you want a property which is dispute free. So always involve a bank, but again it's all depends on this. Maybe you are buying a property where like agricultural land or something. Although if you're an NRI buyer, you should never buy a agricultural land. But if you're an NRI seller who got this agricultural land when he was a resident, or after maybe as a like gift from their parents, or like parents cannot gift, but suppose after the parents are not around, he got inheritance of this property, of course he can sell it. So that is allowed, but buying agricultural land when you are an NRI is not allowed. So always ensure this is done, because it is a FEMA act and it's very stringent. So the last document is sale deed, as I told you. So generally what happens, there are two conditions, two cases can happen. First case, when you come through agreement to sale route. So agreement to sale route, when you come, then once agreement to sale is signed, buyer has to run to his bank, and then his bank has to make payment to seller, and after making full payment of seller, minus the TDS. TDS part also will be paid to seller, but not directly his bank account, but his income tax account. So the money goes to seller, but it goes to his income tax account, where seller can file return letter, and if there is more taxes has been paid, he can claim refund, of course. But after all these things, either the payment goes to his bank account or his income tax account, the full payment is made, then they will go for the next document, which is called sale deed. So once sale deed is done, the deal is completed. Seller has received all the money, and he will hand over the possession of property to buyer. As I told you, second scenario can happen when you are not involving any bank, so you can directly pay the whole amount and go for registration of sale deed. So the agreement to sale doesn't come into picture, because you are paying completely from your own pocket. And in that case, once sale deed is done, seller received all money, buyer will get the handover of the property, and deal is completed. So this way, these 5 documents or term you should understand, which I told you, starting from MOU, then there is search report, third is valuation, then agreement to sell, and then 5th is sale deed. So these are the document or the terms you will hear every time you go for buying or selling property, and you should be very much aware that what these documents or terms stand for. So if you have any other confusion as an NRI buyer or seller about buying a property or selling a property, put your question as a comment. Either me or my team will come back and explain you. If something related to very personal or which require our time and efforts, definitely we are going to charge some consulting fees for that. So that's all in this video. Thank you. Have a nice day.